Okay, good morning, everybody. Welcome to our Hill Dickinson webinar, the first in our ICB Developing Picture series. This morning we're talking about commercial estates and procurement perspectives. I am Esther Venning. I'm a partner at Hill Dickinson, and I'll be talking a little bit about delegation and contracting in the new world of ICBs. I'm joined by Lucy Probert, who's a senior associate in the team, and Lucy's going to talk to you about procurement, and Andrea Proudlock, who's a partner in our real estate team, who's going to talk to you about estates issues. So just some housekeeping before we start. You'll notice that all of your microphones and cameras are turned off, so that we can run through the presentation and take questions at the end. If you do have questions as we go through, then do feel free to pop them in the chat and we'll address them at the end of the session. The webinar this morning is being recorded. You should have a little notice at the front there just telling you that. So just to be aware that's being recorded, and we will send the recording and the presentation slides to you in a follow-up after the session. So let's move on to our agenda for today. So I'm going to just talk a little bit about just scene setting of what the ICB in the new world looks like, what the ICS looks like, and what the new sort of organisations and collaborations are in that space, because that sets the scene then for how the ICB is operating and how that impacts on contracting and also on procurement issues, as well as the estate. I'll then move on to delegation and contracting specifically before handing over to Lucy to give you a procurement update. And then Andrea will talk through some of the estates issues that we're seeing for ICBs coming up. And as I said, if you have any questions during the session, please pop them into the chat and we'll deal with them at the end and seek to address as many of them as we can, depending on time. Okay. So in terms of scene setting and the new system, just as a sort of reminder really, and many of you will be familiar with this hopefully, but it is quite a complex picture now in terms of how the integrated care system is structured and all of the different organisations and collaborations within it. So as you'll all know, the CCGs were dissolved on the 1st of July last year, and the integrated care boards were established, and the ICBs have basically taken the functions that were the CCGs into the ICBs, generally speaking on a larger scale. So most ICBs have multiple former CCG areas within them. And that's so effectively we've become bigger in terms of a commissioning organisation, which is what the ICB ultimately is from a statutory perspective. That creates quite a lot of complexity around how the ICB discharges its functions to arrange and commission health and care services across its entire geography. So thinking about some of the ICBs in the north, for example, we've got North East North Cumbria with I think 13 or 14 different places within it, i.e. CCG areas, former CCG areas, and equally Greater Manchester I think has 10. So they are much bigger organisations and require a lot of thinking through in terms of how they operate and how they discharge those functions. So we've got the ICB there at the centre. The blue on this diagram is it indicates that those are what are effectively legal entities and statutory organisations. So we've got NHS England obviously on the left hand side there, the ICB, and then at place level, which is much closer to the population and usually on former CCG footprints, but always aligned to local authorities generally. We've got providers, so they will include your NHS trusts and foundation trusts, providers, as well as other providers outside of the NHS and local authorities on that footprint, as well as voluntary sector organisations. We then have the grey, which are those sort of looser collaborations which exist and which you'll all have heard a lot about, but don't exist in law. So they're not statutory or legal bodies. They are effectively at the moment loose kind of collaborations of organisations coming together. So the first one there that you can see is provider collaboratives, and that is very much a hot topic at the moment. All NHS trusts and foundation trusts are required to be part of a collaborative within their system. And most collaboratives now have some fairly in most cases quite loose governance arrangements, bringing them together to look at how they can work together to deliver care across a bigger scale, reduce inconsistencies in care and make efficiencies. So provider collaboratives are very much a hot topic, and ICBs I think are generally looking to work out what the relationship is between the ICB and provider collaboratives, as well as their relationships with individual provider trusts within those collaboratives. So from a contracting perspective, that creates a little bit of complexity moving forward. We then have place-based partnerships, which are collaborations of health and care organisations at place level, so usually coterminous with local authority. And they are very diverse, as you can see on the slide there. So they will include primary care organisations, voluntary sector, as well as local authority, the provider trusts, etc. within them. Most of these place-based partnerships are, again, loose collaborations. They have been operating in most areas for some time, but don't necessarily have the delegation as yet from the ICB or other partners to actually commission services themselves at place. So again, that's another kind of area that the ICBs are looking at as to how they use place-based partnerships to deliver their commissioning, to arrange services at that local level, and as close to the population as they can, which is the idea of these changes effectively. So that's the system as it looks at the moment. So from a delegation and contracting point of view, we have the Health and Care Act 2022, which obviously established the ICBs. And the position broadly at the moment is that ICBs have those functions that CCGs had, and they will need to delegate and or contract with providers, NHS trusts, other providers to deliver those services in the way that CCGs did largely. And most of those arrangements have just transferred across to ICBs as is. And ICBs are now looking at how they can start to pull together some of those arrangements to commission them at a larger scale and how they actually organise themselves from a contracting perspective. We've also then got obviously place-based partnerships, as I've said. The picture in terms of place-based partnerships is really quite mixed in our experience. So in some areas, place-based partnerships have got quite a bit of delegated authority and delegation from the ICB to undertake functions on behalf of the ICB at a local level. But in a lot of cases, ICBs haven't yet delegated much to place, and usually that's because of the level of maturity really of these relationships, but that will develop over time and should develop over time. We've got NHS England in the corner there. They have already delegated primary medical services commissioning to ICBs in much the same way as they did to CCGs for a few years. But from April 2023, this year, they will delegate all primary care commissioning to the ICB. So that's quite a big, so that includes dental services, for example, and ophthalmic services. That's quite a big shift into ICBs in terms of that responsibility. Specialised commissioning remains at the moment with NHS England, but there is that is likely to come down to ICBs as well to manage and deliver and contract for, usually working across several ICB areas given the nature of the services, but it's not expected that that's going to happen in full until 2024 at the earliest. So delegation and contracting. Let's look at some of the tools that we've got. So we've got some new tools in the Health and Care Act 2022, which enable ICBs to delegate and to their functions to various different organisations, including NHS trusts. That was not possible before the Health and Care Act 22. So before that, they were not able to ask providers, NHS trusts and foundation trusts, to actually arrange for the delivery of the services and commission the services themselves. ICBs would have to do that themselves and contract for the delivery of those services with the trusts. So these tools allow them now to do that. So one snazzily entitled Section 65Z5 is the main new tool for ICBs in terms of being able to delegate to those other organisations. It's also relevant for NHS trusts and providers, and this really comes into the provider collaborative discussion. So it allows provider collaboratives of trusts and foundation trusts to come together and make decisions together and delegate to each other, which again they could not do previously. So 65Z5 is going to be a really key tool for ICBs, and it basically allows what's termed a relevant body to arrange for its functions to be exercised by another relevant body, or to exercise them jointly with another relevant body, or a local authority. Where they're doing that, they can also set up a joint committee, and we're expecting to see much more joint committees being set up, and a pooled fund can also be established. And those of you that are familiar with Section 75 are probably familiar with the term pooled fund, but effectively it allows you to put a pot of money together, contributions from everyone in the arrangements, to spend on the services and make decisions together. Where these powers are being exercised, they need to be set out in a delegation agreement. Now, that delegation agreement will set out the scope of the delegation. So what is it that we're actually delegating? What does that mean? What are we putting any conditions on the exercise of that delegation? So what can and can't they do with that delegation? It's possible that you could potentially set that out within the commissioning contract that might go alongside it as well. But a good example of a delegation agreement is the primary care delegation agreement that already exists between NHS England and ICBs, and we expect that that will be used by lots of ICBs moving forward when they want to start to use these powers. So the other tool I mentioned just then was Section 75. That remains relevant. So Section 75 allows local authorities, ICBs and NHS trusts and foundation trusts to delegate functions to each other within the realms of the relevant regulations, and to pool funds in relation to those functions, and to set up joint committees. It does remain relevant because local authorities are not relevant bodies for the purposes of Section 65Z5. So whereas you can have a joint committee of those different relevant bodies of NHS organisations and a local authority, they can only exercise NHS functions in effect. So the local authority can't use that power to delegate its functions to the other NHS organisations. It can only do that under Section 75. So we expect to see a bit more focus on Section 75 than there maybe has been previously, because that's going to remain the main tool through which we can really integrate those health and social care functions. We also have Section 12ZA in the 2006 Act, which has been inserted by the 2022 Act, and that basically just gives trusts, or gives ICBs the ability to get trusts involved in things like population health activities, looking at how they lead service design across a population, how they might organise those services. And that's, I think, really just to clarify that that is something that ICBs can do, because there has been some doubt about whether that was permissible or not. So it's almost like a halfway house really between contracting as normal and delegation via Section 65 Z5. It just clarifies the position. So in terms of contracting models, for the purposes of this morning, I'm just going to focus on provider collaboratives and how we might start to look to contract with them over time, because we've certainly seen that it's a hot topic for ICBs in terms of how they actually interact with provider collaboratives. What is the relationship with the ICB? What is the ICB going to ask provider collaboratives to do, and how can they do that? What's the realms of the possible here? So most provider collaboratives are I would say emerging in terms of their current state of maturity. So they will have a basic governance arrangement, because that's what they've been required to put down before April last year, April 22. And so they will make arrangements for commissioning via this governance group of the collaborative, and effectively continue to contract with each individual provider. So this will probably be happening in most ICB areas at the moment. And the ICB will nominate perhaps one of those organisations to be a lead to work through how it will coordinate those services, and there will be a loose governance arrangement between them. But at the moment that collaborative isn't developed enough for the ICB to delegate it a budget or to start to delegate any functions to it. It's really the beginning of a conversation around how they work together. And when we move on to a more developed provider collaborative, what we might start to see, and there's certainly discussions happening in various ICB areas around this, is that it's almost like a hybrid version of that. So we might still continue to contract on the same basis. So we might still have separate contracts, our commissioning contracts with our, say, acute providers in the particular geography, but those acute providers will come together and form their collaborative. They'll have their governance arrangements, and they will be mature enough to start to actually take on responsibility for some of the budgets associated with those services, but not all of them. And there may be some ability to take some joint decisions in relation to those as well. So there will be some delegation happening here, but it's very much a kind of first stepping stone to any sort of full delegation model. So in those circumstances, we'd still have the commissioning contracts with the individual providers. The provider collaborative would have some form of collaborative and partnership agreement. Most provider collaboratives have that already, setting out how they will work together. And then because we're looking at starting to delegate certain things to that provider collaborative to do on our behalf, we would need a delegation agreement with outcomes set in that and the scope of the delegation and the terms of that delegation to the provider collaborative. And most likely it will be a lead provider within that provider collaborative that will have that responsibility. So we'll need a form of delegation agreement, or at least terms on which we're going to delegate to them. So the third sort of potential model is where it's almost like the ultimate endpoint really for provider collaboratives, and the whole idea around having a lead provider in a collaboration who takes responsibility for a set of commissioning functions from the ICB, holds a budget for the whole pathway, for the whole population, and then looks to organise that with its fellow providers as part of the collaborative. So in that scenario, we'd have one commissioning contract effectively with that lead provider. That lead provider would hold that contract for the whole and be responsible for all of those services and budgets, and then would look to subcontract with all of the different providers within that collaborative for the different elements of services that need to be delivered. So we'd still have that collaboration agreement between the providers in the collaborative. We could potentially have a joint committee at that point as well, using section 65Z5, where they come together and start to look at how they make decisions jointly and combine each other with those decisions. And then we'd have a delegation agreement, or at least terms of delegation set out either separately within an agreement or within the commissioning contract itself, setting out really clearly what that lead provider is responsible for by way of the functions of the ICB. When we delegate, when the ICB is delegating, the ICB does remain responsible ultimately and accountable for those functions. So it's really important that it's very clear what the lead provider can and can't do, and what the remit is of that lead provider. So this is very much a future state model, I'd say, and in most areas there might be some discussions around moving to this sort of model, but I think in my experience we're a little way off it for most areas. The one example where this is actually happening, although there isn't yet any delegation happening, but we have a lead provider structure very similar to this, is within NHS England's specialised mental health services. So across the country, we've got NHS-led provider collaboratives led by NHS trusts who are responsible for delivering services across a whole geography through a collaboration of providers. And so that's very much the kind of template model really here that we're starting to look at much more widely. I've said there on the slide that just in square brackets, a little note that procurement law still applies to all of these arrangements. So wherever we've got a new contract being entered into, we always need to check our procurement obligations. And I think there is sometimes that can be forgotten in these sorts of arrangements where they are much more collaborative, and we're looking to perhaps contract with our local providers rather than potentially opening up the market. So it's important to remember that we do still need to consider procurement. And on that note, I will hand over to Lucy to talk through the procurement issues.
Thanks, Esther. Yeah, so I'm just going to give a quick update really on where we are in terms of procurement law. Obviously, this is an area that's in kind of huge flux at the minute because with Brexit, obviously all procurement law in this country previously was European derived. So that has left the UK with an opportunity to kind of develop its own procurement legislation, which it obviously has done. There is a draft procurement bill out there. It was published first back in May 22. And we've had a revised version since in November 22. I had a look on the parliamentary website last night because they publish kind of regular updates as to where it is. It's had its second reading in the House of Commons, and it has gone back into committee for a kind of line by line read through now. So we will have to see what comes out of that. But essentially, the whole drive from the government in terms of its procurement policy now is to give, it very much adopts the kind of familiar principles of procurement, but the intent is to give much greater flexibility for how kind of the UK uses its public money. I've said here, look, the language is really familiar in places because it is. We're not seeing kind of a wholesale kind of destruction of the procurement principles that we've all worked with. You know, it's very much still built on the same kind of principles, but there is quite a shift here. So it's obviously something that any procurement practitioners, ICBs out there commissioning, need to be aware of. What I'm also going to cover off towards the end of the section is also the provider selection regime, which is obviously a big change as well, because it takes healthcare contracts outside of the remit of the public contracts regulations, which is obviously where it sits now. So that will obviously have its own kind of regime, and I'll talk about that as we move through. I've just put at the bottom of this slide, slow progress through Parliament, 2023 at the earliest with 6 months notice. We're expecting the bill comes back out of committee on the 23rd of February, and the government website does suggest that there will be an update at that point as to implementation. But, you know, if you're wanting to kind of get ahead, the draft bill is out there. You can read the regulations that are proposed, and indeed, I think there's an open consultation still on them if there's anything that people want to submit for the committee to consider. So moving on then. The first slide looks at kind of the principles and objectives here about what the procurement bill is trying to achieve. As I say, you start reading it and it does seem very familiar. You have the procurement objectives in the wording of the legislation that are still, you know, kind of very familiar principles: delivering value for money, maximising public benefit, sharing information for suppliers to understand procurement policies and decisions, and acting and being seen to act with integrity. Now, I think the thing to say here is that there's sort of a kind of there's a slightly conflicting drive here between sort of the UK's desire to be kind of an open market and to encourage SME access, but also, and sort of reduce bureaucracy, but also to have, you know, high levels of transparency, regulation, anti-corruption, which all comes into the integrity bit. So it's quite interesting to see how the government has dealt with that in terms of what is being proposed. So you've got much greater flexibility in these new regulations for the contracting authority, but you still have those sort of general kind of tenets of procurement law, you know, equal treatment of suppliers. Interestingly, there isn't an independent independent sort of stated obligation for proportionality anymore, but always it's kind of underpinning the decisions that a contracting authority is expected to make. So, you know, it always, quite a lot of the regulations, whenever there's a decision to be made about how you're procuring or what you're procuring or the way in which you're procuring, it has to have sort of regard to what is proportionate for the nature of that contract and the complexity of that contract. I've said, obviously, I've already mentioned the transparency requirements. They've said, oh, we're going to make it a lot easier. It's going to be a lot easier to sort of for suppliers to access, and it's going to be a lot easier for contracting authorities to manage bureaucratically. But there's actually more notices required under the new legislation than the old one. The key kind of catchphrases that you see in the kind of explanatory notes are sort of things about being quicker, simpler, more transparent. But it's kind of how that plays out in practice. I don't think it's quite clear until we start implementing these regulations. So moving on, they're also going to implement a national procurement policy statement, which is going to be published periodically, and that's to give these it's to give the regime a bit of flexibility, so that you know, where we're then purchasing kind of nationally, there's some kind of set way of doing it. Now, actually, they already kind of have that through the PPNs operating, you know, in sort of mandating how bodies procure and what they're thinking about when they procure. They're going to formalise that into a national procurement policy statement, which will be published periodically. There's also quite a lot of regulation making powers here. So essentially, again, it's all about building flexibility into the legislation. The government will be able to add in additional sort of bits of regulation that can be mandated from time to time that then providers will have to, contracting authorities will have to consider when they are then developing their procurement procedures. And in terms of sort of, again, what I've tried to do here is distill the sort of highlights of the draft legislation. We have a very much kind of simpler set of procedures to work with. There's three stages under there. I mean, they all feel quite familiar, but again, it's kind of trying to build in those tenets of flexibility. So we have an open procedure, a competitive flexible procedure, which can be designed as the contracting authority wishes, and there's obviously still direct award is still available. We've got a move away from most economically advantageous tender to contracts being awarded on the basis of MAT, which is most advantageous tender. Now, again, some say, oh, well, this is very new. It's quite good because it's sort of defining value as something that isn't just kind of economic. But we've had that for many years in the UK procurement legislation. We've had things like the Social Value Act that sort of, and we've had actually PPNs mandating sort of a more holistic approach to what value is and to building in social value into procurement. So again, question if whether that's really a huge change, but it's quite interesting to see it reflected in sort of the principles of procurement. And as I said, look, there's an example again of sort of things being less rigid. So the procedure as the contracting authority considers appropriate, and it always has to be with that principle of proportional. A proportionate means of awarding the public contract having regard to nature, complexity, and cost. Sorry, something's just happened to the slides. Right, sorry. Okay, so as I said, I've already mentioned direct award is still available. Again, this is another one that feels quite familiar. What the government is saying here is, yep, direct award is going to be available, much like it is already under Regulation 32 of the PCRs. The grounds for direct award are very similar. You've got the sort of kind of protection of public of services where there's an urgent need. You've got general rights about IP, prototypes, etc. And you've also got additional repeat goods, works or services. So again, those are all very much kind of familiar principles. Competition, I would say, is still at the heart of the new procurement legislation. The default position is that you procure where the procurement rules will apply. bearing in mind that what I've just said about PSR taking healthcare contracts out of there, that's dealt with slightly differently. But generally, you know, the position is still competition. However, you have this provision for direct award. Obviously, in commissioning for the public sector, the use of dynamic purchasing systems and frameworks, that's very, very common. How does the legislation treat those? Well, in terms of the the DPS, they're replacing something called dynamic markets. Again, it's quite similar to the way a DPS works at the moment. You set out your conditions for membership, your qualification standards. Anybody can join at any time, and you have an unlimited number of suppliers who can be on them. Probably of more interest, I suspect, to the group today is frameworks. Frameworks are they're sort of changed and unchanged under these kind of new regulations. So again, you've sort of got that familiar kind of framework set up for 4 years, unless the contracting authority considers the nature of goods mean you should have a longer term. It's not quite clear what the position is in terms of kind of call off. It's clear that you can have mini competition and you can have direct awarders now. What is more of a major change is the idea of what they're now calling open frameworks, which is introduced by this legislation, which is the idea that obviously the disadvantage of setting up a framework is you lock suppliers out of the market for the set period of the framework. What an open framework would do is after a certain period, you award on, and then after a certain period, you can actually open up again and award additional suppliers onto the framework. So it's almost like a scheme for awarding successive frameworks, but it takes away that sort of disbenefit of the framework that you're closing down the market for the whole period. So again, how that works in practice, we'll have to see, but it's quite an interesting concept, and it's obviously an attempt to sort of address the kind of problem, if you like, of people being kind of shut out of the market during the period of a framework's operation. So really, I mean, that was a very quick gallop through the procurement bill. I mean, as you can see, it's very much kind of consistent with what's there now, albeit that there is this kind of greater flexibility. How it comes out of committee, I don't think there'll be radical change, but it'll be interesting to see, because obviously they've consulted on this, so there will be, I suspect, further amendments as we go on. So given the audience today, I thought I would also go into a little bit of detail about the provider selection regime, albeit that there's not a huge amount beyond what's on the NHSE website out there at the moment. So the PSR, the provider selection regime, has been introduced specifically in relation to healthcare services. So it's healthcare services as defined by the NHS Act. Now, this slide is slightly misleading, I discovered when I went on NHSE's website last night, because it says that expected that PSR will come into place maybe April 2023. The latest on NHSE's website is that it will be July. Let me just double check that. Yes, July 2023. So again, now the way that this fits in with the procurement bill is that it takes healthcare services entirely out of the ambit of those regulations, which means that when you then make decisions about commissioning healthcare services, you're no longer looking at the light touch regime or the obligations there, which kind of assumes a competitive process. The PSR is quite fundamentally different in that it allows the authorities to make a decision as to whether a competitive procurement exercise is really the best way to run the procurement, or whether actually there's a better way of doing it through the application of criteria. I'm so sorry, I've got my slides in a muddle. Yes, so I'm just going to, yeah. So So the point is, what will happen is, instead of deciding on a competitive process, the new regime will give providers the ability to decide. It's kind of 3 decisions: whether they run on what they've got with their incumbent, and justify it, whether they can identify a particular supplier who ought to take the contract, or whether there is a competitive where you can't identify the best supplier to provide those services, then you will run a competitive procedure. But it's no longer the case that you kind of have that default to competitive process, and that will obviously change quite a lot. It gives quite a lot of powers to commissioners to decide how they commission. Now, the decision making will work on a set of principles. Again, all of this is available on the NHSE website, where you can have a look at sort of there's some explanatory information about the policy drivers, and you can see from this slide how that was sort of come about. So there was various consultations on it. The overriding duty when you're making a decision is that services are arranged in the best interest of patients, taxpayers, and the population. And the decision-making criteria are very familiar. It's things like quality, value, integration, and collaboration. And the emphasis is on creating that seamless patient experience, and then also kind of access, inequality, and patient choice. So it's sort of, again, you can feel the sort of the same drivers that were there from the Competition and Patient Choice Act. You can see where the drivers are coming from the PCR in terms of, can competitive process drive value, but it gives much greater flexibility. And there's also the opportunity for some mixed procurement. Now, as I say, the PSR applies only to healthcare services, but there is the opportunity where healthcare is the main subject matter of the contract to also bring in elements that sort of help with kind of, again, creating that seamless patient pathway. So you could add in some social care services. There's a potential for that, but it's not. It's only where whatever you're adding in, if procuring it separately would adversely kind of impact patient care, it wouldn't be in the best interest of the patients, the taxpayers, the general population. So again, what I want to stress here is that, okay, the position now is that everything is under the PCRs, all healthcare commissioning until PSR comes in is still subject to the light touch regime. Once PSR comes in, it's healthcare contracts and only healthcare contracts, which are caught by the PSR, and everything else will still need to be procured under whatever comes out, whatever they choose to call that piece of the legislation that the procurement bill creates. So you will have this kind of separate regime for healthcare contracts, but there is quite an exciting opportunity there to also work out, where you've got the primary aim of healthcare services, if there's anything else that needs to be built into it in order to create that kind of seamless pathway, which should actually help commissioners with kind of the headaches of when you've got things that are subject to different regimes. Okay, I appreciate that was a really quick gallop through procurement legislation, but there's a lot out there. We're going to try and keep you up to date. Yeah, I will hand over to Andrea now to talk to you about estates.
Hi, everybody. So all of these services that we're talking about have to happen, or in the main, have to happen somewhere. So the estate is actually very important in all of this. And you can see from the picture that the ICB estate is hugely diverse, and I call it ICB estate. Obviously, you don't own all of the properties within the estate, but you are the overseer of these properties, and you will have some that you've inherited from the CCG. So if you think that NHSPS have about 10% of the NHS estate, they think that that's 3,000 properties with 7,000 tenants. So you start to get an idea of the actual size of the estate, and it's ranging from listed buildings to community centres to private residential houses that are used as GP surgeries through state-of-the-art integrated campuses. So you've got a huge range of buildings actually in there. So it's a challenge. So I wanted to just have a look at what we think that those key challenges are. So these are the key challenges that from advising ICBs on healthcare real estate, our team feel are the key things that we're seeing looking as an outsider in, and from conversations that we've had with clients. And I think firstly, the one to mention is the actual size of the estate and getting a grip on such a disparate selection of properties. So whilst you've got the acute estate with all of the hospitals that will be pretty well documented, except I suspect in relation to actual occupiers of parts of those hospital buildings, you're going to have a lot of primary care estate where that just is not the case. So even get this exercise of getting a list together of properties that you are overseeing, never mind tenants and occasional licensees within those properties, is mammoth. And I say that this is a challenge. I appreciate that you're not taking ownership of all of these properties, but you need to understand your estate before you can start to work out how you're going to deal with it, how you're going to maneuver it around, how you're going to plan to deliver this great integration and place-based care. The estate is absolutely key in all of that. You've then got disrepair. I mean, we hear about it in the news all the time, don't we, about NHS backlogs and everything like that. And it really is becoming, with the lack of funding, even more and more of a concern. And actually, in some of these privately run buildings that are run by private landlords as well, I mean, it can be still a big issue. So you've got this issue over health and safety. So that's health and safety, really, if you are the main tenant of the building, but also you've got this worry if you are a provider delivering clinical services from a building that is in disrepair, because basically how it stands, you will be on the hook for any corporate risk should there be anything that occurs to that patient whilst you're delivering the service from that property. So we've already started to see NHS trusts in some areas of the country asking GPs, for instance, to say that the building and the premises that they're going to be operating and delivering these clinical services from are actually safe and fit for purpose. And as we start to see clinical services move more into the community, this is obviously going to become more and more of an issue. The next thing really is knowledge gaps. So we've got knowledge gaps, legacy from taking over transactions from the CCGs. Those transactions need to be understood. You've lost personnel along the way who were maybe dealing with those transactions. So trying to understand why things were agreed, why things weren't agreed is obviously tricky. Then you've got knowledge gaps in general, and that's knowledge gaps perhaps in the people who were doing the estate for the ICB, but also across the estate, because you're going to be having GPs and people who don't have expertise in property law receiving notices, trying to enter into licenses, letting people into properties. And I think that's one of those things, as you look at the estate, look at trying to mould it, that you need to kind of try and breach that knowledge gap and, in fact, do some training around it so that GPs and people do understand what's going on. And, we are providing some training actually to Primary Care Connect in relation to that. So if anybody would like any training on specific knowledge on estates later, please do just let us know. So we can add into the mix as well these IFRS 16 accounting rules, which sound highly technical and like they wouldn't really affect much, but they affect everything, because basically leases that used to be off balance sheet are now on balance sheet. So that means if you're entering into a lease for £450,000 a year for a 10-year lease, you now got a liability on your capital balance sheet for 4.5 million. So that is really affecting how people are looking at estates and is, is worrying, and in some instances you need to involve NHS England in that. So people are coming to terms with that as well, and obviously that's going to affect how you look at the estate and how you change it in the future and how you document occupancies. So where do you start? I think the first thing is really to understand ownership. This isn't actually perhaps as difficult as it would seem. We can do PN1, such as at the land registry. A lot of the land in England is now registered. We've got access to systems such as Orbital. So if you've got an address, we can find out the legal documents that sit behind that address, so we can identify ownership. So if you know the name of someone and you want to know how much estate they've got, we can help with that. So as I say, you're the custodian of this estate rather than owning it. But still, you need to understand all of this. You have got powers to buy and lease property as well. So it could be that you're going to start to look at taking interests in some of these properties, maybe taking leases over a larger building like NHSPS does, and then underletting perhaps to clinical providers. I just wanted to touch on this briefly so you could just kind of see how complex land ownership and occupational interests in land actually are. So we've got different types of land ownership. We've got freehold, which is probably how you own your house. You've then got leases, leasehold. So leases are the way in which a lot of third parties will occupy the estate. Leases are tightly regulated. There's years of case law, hundreds of years of case law behind leases and the varying terms in them. And leases will very much dictate what you can and what you can't do in relation to a property, whether you can share the property with someone, what use you can put it to. GPs will be very concerned about leases and to make sure that they're able to get the rent reimbursement back, and there's specific clauses that need to be in that. So, you know, there's a British Medical Association lease out there, which is really a good one to use, which is accessible to everyone. You can just, you know, get it from the website. Then you've got licenses. Now, these are things that won't show up at the land registry. These are just contractual relationships that you can't share your ownership, but they're shorter documents, they're quicker and they're cheaper to put in place, but they're for use for when you're sharing premises with people, when you're all mixed in together, or sessional space. So if you just want it on a Monday, Tuesday and Friday afternoons, you have to watch out with licenses though, because if you do use them just as a short stopgap in space where you've got exclusive occupation, the problem being that if you're in there for 12 months or more, then it will start to merge into a lease and people can start to get all sorts of different rights. So you do have to be careful around them. We've got tenancies at will even. That's a tiny interest, contractual interest in land. And basically, you know, parties can actually just terminate that at will. So as an ICB, you need to understand the terms on which properties are occupied, and all of them have got positives and all of them have got negatives and the circumstances which suit each of them. But you do need to understand these to know how to change and adapt the estate. And I've put at the side some NHS specific types of occupation. Obviously, you get PFI contracts across the public sector, but in lift buildings, you'll find things called lease plus agreements and under lease plus agreements, which are kind of like, I always think they're kind of like semi-PFI type contracts. And you'll find these in CHP buildings. And I would just say with those, if you do come across these, you know, dealing with this sort of estate does take longer because the leases are more intricate. So build time into any program for that. And if you're looking at trying to terminate a PFI contract, then you need to actually be talking to NHS England in the first instance. So things to look out for. When should I pick up the phone? Well, things to look out for, if you're looking at the acute estate, then actually a really, really useful document to look at is NHS Estate Code. And that has got lots of details in relation to what you should find in leases, what should be in there and what shouldn't be in there. And that's got key terms to include in transactions, freehold transactions as well. And actually, do you know what? It's a really good starter for 10 for anybody who's perhaps delving into this area for the first time. So I'd really recommend people pick that up. I think it's Health Building Note 8. If you're looking at freehold land or developing land, be aware of covenants that restrict the use of land. They could be that you can only use it as a house, but you might see something on there that says you can only use it as a house, but actually there's a lot more detail behind that. When was it put in place? Who put it in place? Can you get insurance to cover it? So, it's not necessarily something that would stop development, but it's something that you need to be aware of and investigate in the first instance. Leases, as I say, they'll tell you what you can and you can't do. You've got to be very careful around breaches of terms of leases. So you shouldn't really, if you want to do something which the lease won't allow you to do, then you really do need to be talking to the landlord about it, because if it's a really fundamental breach, the lease could be taken away from you. So I would suggest that if you're looking at leases, especially if it's notices, I mentioned notices just later, but notices under leases, they are a really specialist area of law. I wouldn't touch a Section 25 notice or a break notice. I would always get somebody in property litigation to do it. So I would suggest that if anybody is in receipt of notices like that, that you really do just pass it across to your lawyers as soon as possible. If you're considering works, then you've got to think about procurement as well. So services, if you're procuring a clinical service and there's going to be a building that goes alongside it and you want to procure all of it, then you need to make sure the works are in that procurement exercise. You need to document what the works are to protect yourselves, to protect tenants and building contracts. So all of that requires at least an oversight from a lawyer to check that there aren't any massive clangers in there. Then there's the role of the district valuer. It's particularly important in my book if you're looking at leases with GPs, because it ties in with rent reimbursement, and GPs will always want full rent reimbursement on any lease. So the district valuer and what he thinks is open market rent becomes really, really important. Then finally, you'll want to be tying in leases to clinical services, or maybe to the doctor's contracts. Clinical services often are for like a few years, and then there's a rollover period. You want your lease and your clinical services to be very much tied in together. So if the clinical services stop, so does the lease. It becomes tricky to do this if you're looking at using a property for this, because a landlord won't particularly like somebody coming in and changing services. They like certainty in tenants. So it might be that you start to look at putting in a lease to the ICB and then you underlet to different parties within that building. So the landlord gets the certainty of the rent and the continual tenant from the ICB, and then you can operate as you like beneath it. Certainly in places like shopping centres and stuff like that, if you're thinking about putting in community diagnostic provisions, commercial landlords would very much like to see that guarantee of the rent with like a NHS body, and then will allow you to do what you need to do beneath that. So looking at the future of the estate, there's lots and lots of opportunities to look at the estate and to see how, what can you do with it? How can you mould it? There's certainly opportunities in relation to using the NHS trust estate with surplus properties there. You can go in, you could take a lease, you could put money into it, make it more sustainable. So I think that's a really interesting prospect. You could look at moving GPs into purpose-built accommodation, which people are looking at in any case, and moving them out of private residential houses. And I think things like this are going to be particularly important, considering the new MEES energy provisions regulations that are coming in around when which prevent people from letting property where I think it's under an E category. So a lot of the accommodation that GPs are in is probably just not particularly fit for purpose. You've got the fact that you can pool resources with the local authority. They've got, they're desperate to get people into city centres. Again, you can find shopping centres that are local authority owned. You can work with them to bring in stuff. Obviously, you've got issues there potentially around the actual practicalities of it. Does the space work? How much cabling do you need if you're bringing in scanning stuff? Like, what do you need for your electricity supply? So, you know, perhaps it's better for things where you don't need like massive, like, you know, obviously an MRI scanner or massive scanners. That wouldn't necessarily be the right place to think about delivering a service like that. But you could certainly bring in stuff where you've just got treatment rooms or consultation rooms. Community diagnostic centres, obviously key at the moment, and that's something that people are really looking at. You know, whether you do those yourselves or they're third party built. If it's third party built, then people will try and will reclaim the cost of the works through the rent. So you need to be aware of that and how you deal with that, and rent reimbursement if you're putting well, not rent reimbursement. I mean, that would be in relation to GPs, but you know, you just have to be aware of the cost of that, and the fact that if you do take a lease of it, then and you want to terminate early, there will be costs to pay. So can the private sector help? Well, yeah, probably they can in some way or another, especially at the moment when people are cash strapped. But you have to be aware that, you know, private sector funded developers are very savvy, very commercially savvy. So if you think it's too good to be true, it probably is. What you need to make sure is that when you are dealing with the private sector, firstly, if it's individual, say GPs that are perhaps dealing with the private sector, that you can stand behind them and give some clout perhaps to those discussions that are ongoing. And also, you need to make sure that you are as savvy as the private sector developer, so that you also have proper surveying expertise on your side. Obviously, there's a lot of expertise within the NHS acute system, which you could use. So that's really a quick canter through estate.